Vanakkam. I have postponed my Tamil learning project because I have to deal with Telugu first. But eventually, I hope to be a little more literate in your great language. My distinguished colleague, Mr. Chidambaram, all the eminent people on the dais, Mr. Chodankar, who has been an invisible client for a substantial time, so I'm glad to see him in person. Mr. Selva, Mr. Rajesh Kumar, a special word for Mr. Elango, who is as much a part of this function as the Congress unit. In fact, I had the privilege of chairing this department of the Congress over 10, 12 years ago. But I can say that of the various events we've done, this is the first truly federated event, an event fully combining the DMK support with the Congress as far as the law department is concerned, and he and Chandramohan have been in touch with me over the last several days. It is of course a happy coincidence that when this was originally scheduled, the judgment I think had not come, and then because of some particular lecture I had to give in Delhi on the Ambedkar Jayanti, this was postponed to today, and the judgment has happily come, so it has become more topical. But as you will see, I want to paint a larger picture of federalism for you, a much larger canvas, within which of course the role of the governor is an important part. But before I start on the topic advertised for today, I don't understand Tamil fully, but I gathered that Mr. Chidambaram talked of the whole legacy of lawyers in the Congress. So I just wanted to touch on that for 30 seconds, to start with the first president of the Congress, who was a lawyer, and to not repeat what he has said, but to remind you that sometimes the legal community is itself not cognizant or aware of the humongous power it wields. Each individual lawyer has a huge power to convince, to persuade, to influence, to change the perception of all those who are his neighbors in the taluk, in the district, in the state. And it is this vast reservoir of unutilized power which must be leveraged and exploited and used by each one of you as soldiers of whatever cause you believe in. Friends, let me turn to the topic advertised for today, diverse perspectives on federalism. And let me start by putting it in a contextual setting, which is the setting of India. India has several institutional pillars of Indian democracy. The CAG is one, the Election Commission is one, even the army is one, certainly the Supreme Court is one. Even more important than the institutional pillars of democracy are the non-institutional pillars of democracy. Secularism, socialism, a little used word, fraternity. And in that top slot, along with these non-institutional pillars of Indian democracy, sits federalism. In the context of planet Earth's most diverse spot, there is no more diverse spot on planet Earth than India. The second largest, and now possibly the largest population soon, the diversity of smells, sounds, rituals, religions, ethnicities, languages, diets, foods, races. It's a bewildering array, from 22 scheduled languages to 700 mother tongues to 2,000 dialects, the birthplace of 4 religions, the second or third largest collection of 2 other religions. So you cannot ignore this diversity which links directly to the topic we are going to discuss shortly, federalism. The second broad head I want to touch upon is the concept or the types of federalism which you have across the globe. Federalism is a word derived from the Latin word fidus, which means a treaty, a pact, a covenant. And there are many, many types of federalisms. There are federations, there are confederations, there are unitary systems with some concessions to federalism, which is what India has been historically described as. There are truly federal countries like the USA, what you call bottom-up federalism, where pre-existing independent countries, many of them, ceded power to form the United States of America, as opposed to top-down federalism, which is the Indian model, which is basically a central sovereignty with some federal features. But at the end of all this, we must remember that our seminal opening words of the Constitution, "We the people," combine something frequently forgotten, combine two sovereignties, not one. A central sovereignty and a different kind, but still a state sovereignty. Both lie in "we the people." The approach with which we came to federalism in the different models is also different. The legacy, the historical context, the preceding events were all different. For example, in USA, the principal overriding, almost obsessive theme was of interests. How to prevent the tyranny of one state over another. They'd just gone through the British experience, and therefore they wanted to diffuse power as much as possible, which is why it was in fact a true federal system, bottom-up, pre-existing countries diluting and ceding their sovereignties to form a country, a new country. And the idea that each state must be absolutely equal irrespective of population. That's a fundamental difference with our federalism, which is population-based. As opposed to the interest focus of USA, federalism in India has always had an identity focus. And that is a broad, original, philosophical, historical difference we must keep in mind. My third head, which I want to touch upon, is a very interesting paradox, a remarkable paradox in fact. The first part of that paradox is that by constitutional design or by institutional design at the inception, India was to be almost entirely a unitary country with some concessions and some kind of give and take minor towards the concept of federalism. There is no doubt that the conception and design was heavily unitary, which is what led to a famous Australian teaching at Oxford, Kenneth Weir, coining this apt phrase. He said India is quasi-federal, which is very mildly federal or pretending to be federal, is largely unitary. In fact, if you Google the word federal in the Indian Constitution, you will find no word federal. It's quite amazing. India is one of the longest constitutions in the world. At one time, the longest, is now one of the longest. In the entire constitution, there is no word federal. Don't be misled by the word federal, which you will find in several articles like 112, 128, 135, etc. That word federal is not the federalism or the federal we are talking about. It is the reference to the federal court, the predecessor or the precursor to our Supreme Court. But otherwise, in the preamble downwards, there is no federalism in the Indian Constitution. The paradox I'm going to address very shortly is this remarkable paradox that two paradoxes, in actual operation, India is much, much, much more federal today, 75 years after independence, than it was conceived. And the second paradox, that something found nowhere in our Constitution has been held more than 30 years ago to be a part of the basic structure of the Constitution. So you don't have to be having an honorable mention in the Supreme Court, in the Constitution of India, to be part of the basic structure, because federalism has been held from way before even 94 or 93 to be part of the basic structure without finding a mention in the Constitution. But just to complete my other examples of basically a heavily unitary country with some federal concessions, there are a large number of articles which you might not normally see, which would never be there, for example, in America or in any other largely federal system. For example, Article 248 says anything not in the lists given to the center or elsewhere, the residuary legatee under entry 97 of list 1 will be the central government. So all not specified goes back to the central government in terms of legislative power. There are lesser known provisions like 249, where if the Rajya Sabha passes a resolution by 2/3, any law can be enacted in national interest. The words are national interest. There are several other provisions like Article 253, where Parliament can override List 2 for international treaty. And so on and so forth. There are, of course, the emergency provisions, which are in Part 18, starting with 352, where no state sovereignty matters. In particular, the most anti-federal provision, Article 356, so-called President's Rule, also in that Part 18. On fiscal federalism, about which I will talk presently, several provisions which limit by constitutional provisions the power of the states. For example, 292 regarding borrowing requires 293 in particular, borrowing requiring permission of the central government, and so on and so forth. I don't want to take too much time, but clearly in design and conception, in constitutional text, it was never intended to be, and that was understandable because most of our debates in the assembly are very, very concerned, almost scared about the fissiparous tendencies of a country which had in fact not gone through but was going through under their nose the worst cruel throes of the largest migration of the human race, lakhs of people crossing the border, and therefore they were concerned about keeping India as a united country, which is why the design was unitary. My fourth head before you is to very briefly describe the story of how this country achieved what is nicely called accidental federalism or unintended federalism. This is the first part of that paradox. And it starts with the recognition that in the ultimate analysis as the years went by, it was found that federalism as a concept is vital for managing diversities, which is why I started with India as the most diverse spot on planet Earth. It was seen as an inalienable concept of shared and participatory sovereignty, of shared identity, to prevent governance being monopolistic. In particular, it was seen as a safety valve for the 3 Ds. The 3 Ds are dissent, discomfort, and dissatisfaction at lower state levels or lower than state levels. Federalism ultimately is a vehicle which quarantines these tensions, these conflicts at sub-state units or state units and prevents conflagrations and explosions at the center. Something like a pressure cooker where it acts as a safety valve. And that is why emerged this fascinating story of unintended and accidental federalism. So very quickly, and this can be a subject matter by itself of a lecture, so I'm not going to go into details. 6 very significant historical influences, which I'll itemize, led to this accidental, unintended federalism over 75 years, not designed by our founding fathers. The first was linguistic federalism. Fortunately, most of us have not lived through the so-called language riots of the old times in the 60s. But the creation of ethno-linguistic states was a major recognition of federal patterns. And it happened all after independence and after the Constitution. Many of them, and initially, in fact, all of them, were on linguistic lines. Gujarat, Maharashtra, Karnataka, Tamil Nadu, Kerala, Andhra Pradesh. To some extent, much later, Telangana. Of course, later ones were more on political or economic considerations from Chhattisgarh, Jharkhand, and the Northeast. But here was what I call linguistic federalism. Second was the sea change of the courts on the approach to the most anti-federal clause in the Constitution, a directly anti-federal clause like a bull in a china shop, Article 356. If you will notice that after the 2000s, there have been hardly 10 or 12 maybe such over-adventurous incursions through 356, and I've been privileged to appear in most of them. The use has diminished considerably, mainly because of very prompt, immediate, and vigorous judicial review and intervention, which was not the case. If you remember, poor Mr. Ramakrishna Hegde made a petition after he was unceremoniously removed. He won that 3 or 4 years later, by which 2 governments had changed. And his entire actual relief was infructuous. He set the law in Bombay, but he got no relief because so much time elapsed. Post-2000, from Rameshwar in Bihar in the early 2004-5 period, onwards through Jharkhand, Uttarakhand, Karnataka, all these I have personally been privileged to be an actor, including the midnight hearing in Karnataka. Not directly 356 always, but related to 356. Goa, Maharashtra twice, Arunachal. All these, this way or that way, the court intervened. So that an over-adventurous approach, and I'll talk about Uttarakhand in a moment, over-adventurous action under 356 has become much less compared to the pre-2000 period, where there were 99 invocations, as opposed to around 15 or some odd 15 in the last 25 years. So that is the second federating influence in last 75 years, making India a much more federal country. The third and the most important quantitatively, with which a Singhvi has something to do, is the Panchayati Raj revolution. Today, when any of us, whether we are members of parliament or MLAs, when we go to the Panchayat level, sitting across us will be an elected representative, in most cases and not a woman. Over 20 lakh such women and 35 to 40 lakh such representatives across the country. Decentralization is the other synonym for federalism. The 73rd and the 74th constitutional amendments were brought on the basis of the so-called Dr. L.M. Singhvi high-powered committee for revitalization of Panchayati Raj. And I remember, if I may digress personally because his name was taken, I happened to be standing near him when Rajiv Gandhi called him. And Rajiv Gandhi in the mid-80s said that, Dr. Singhvi, you are constantly lecturing about Panchayati Raj, but it is lying in ruins everywhere. You have to do something concrete about it. So I am appointing you as chairman of this committee where you must lay out a blueprint. After his report, a year and a half or 2 years later, and after some politics, it was reborn and implemented as the 73rd and 74th amendments. And it has truly led to the biggest decentralization, federating influence in the Indian Constitution, never dreamt of by our founding fathers. As the former Panchayati Raj minister put it, in the acronyms he's fond of formulating, that it led to the devolution of three functions of the three Fs, functions, finances and functionaries, to achieve the three E's, empowerment, entitlement and enrichment of rural power at the rural level. Of course, the Panchayati Raj revolution has been more successful than even the municipality one, which was the second amendment which went along with the first one. Because in the municipal category, a large number of municipalities exceed their absolute 5-year limit for electoral cycle, despite Supreme Court judgments. But that's another story. There has been no doubt that together, Panchayati Raj and municipal elections or municipal governance has led to a huge federating influence on the Indian constitution. The fourth was the economic liberalization starting from 1985 and with the watershed year 1991. Delicensing, the huge reduction of central government powers. I frequently joke at my addresses for the last 20 years that it may not be out of place to say that a state chief minister, any state, is probably 3 times more powerful than a central cabinet minister, although they hold the same rank in protocol. This was not the case before 1991, because you don't have to go to the central government for most things. That is another form of a federating influence. Then, of course, the most important in one level was fiscal federalism, where there is no doubt that from roughly the 30% devolution from the center, broadly I am saying, in the old days, to the 41, 42 or 43% now, there has been a progression towards federalism, but with extremely important caveats about how it is also sought to be attacked cruelly, which I will come to when I come to the challenges to federalism. But yes, there has been fiscal federalism of a degree not envisaged during our constitutional framing. And finally, my sixth highly paradoxical, accidental, unintended federalism characteristic, and that is the dawn of the era of coalition governance. Leaving aside a few what were considered rightly as aberrations, regional parties have become structurally embedded in the Indian democratic process from 1991. There are cases before that also, but they are now structurally embedded. The regional parties' aspirations, the regional parties' focus, the regional parties' concerns have given an altogether new color to federalism in the political governance level, which it could never have before 1991. And although it may not be true at the moment when I am speaking, but there have been times in the recent past, not too long ago, when more swathes of Indian territory have been under regional party rule than either BJP or Congress, larger portions. So that is a organic growth of a political process which has led to its own forms of a federal thinking. So friends, having dealt with inadvertent federalism, let me turn to my fifth aspect, the challenges, the diverse challenges, where the fifth aspect I will first start with the fiscal federalism challenges. And I'll be brief and a little hesitant because I know I'm sitting with a fiscal expert with an eidetic memory. But still, the first, and there are examples, I mean there are many more examples which you can multiply. The example starts on fiscal federalism with the chicanery and the clear slate of hand. In legal terms, in a normal case, it would be called 420, section 420, which happened with the GST compensation fund. As you know, the Act of 2017 of GST was brought in with a recognition that the states are ceding so much of their taxing power to the central in a new creature called the GST. B, recognition that in the transitional phase, which was somewhat arbitrarily but still fixed as 5 years from 2017 to 22. Before the GST regime settles down or stabilizes, states would suffer revenue shortfalls after ceding their power. And C, therefore, Section 7 said, this is an act to provide compensation to the states for the loss of revenue arising on that account. And Section 8 further said that we levy a cess, which will be a compensatory cess in what is called a pooled GST compensation fund to meet that revenue shortfall. Now, to cut along, I've got the figures from each year from 2017, but I don't want to bore you with all that. To cut a long story short, during and before and after the COVID pandemic, a time arose when a hole, a deficit, a gap of 2,35,000 crores, the figure is 2,35,000 crores, became the shortfall of all the states put together. At that time, the funds to meet it was zero. The central government scrambled and came up with a figure of 97,000 crores, which they said they will distribute. And they did distribute that. And then in an amazing sleight of hand, with a stroke of the pen, they said, the rest is written off as an act of God. So you had force majeure on top of federalism. The act of God could have been postponed into future progressive installments. The act of God could have been ameliorated by 1,000 different measures. The cesses could have changed. But that whole figure, remember, was permanently written off. Permanently. Of course, fiscal federalism has other examples. Many. 5 broad ones, and I will not deal with them, is the constant lament of states about the share of states in central taxes. Second, the end of the GST compensation I've dealt with. Third, the center's support for state borrowing programs. Fourth, the union government's lack of receptiveness for special assistance in drought or flood conditions on a selective and somewhat partial basis qua certain states. And fifth, the funding of large infrastructure projects in states. But the most important of these complaints relates to Article 293, which I'll come to in a second. But after telling you some other interesting figures, which Chief Minister Siddaramaiah of your neighboring state has been lamenting about and shouting from the rooftops. He said very recently, he said, if we collect 100 rupees and give it to the government of India, we meaning Karnataka, we get back only 12 to 13 rupees back. And then he furnished a calculation. He then further lamented that the state's devolution of funds has decreased from 4.71% in the 14th Finance Commission to 3.64% under the 15th one. To similar effect is Mr. K.N. Balagopal from your neighboring Kerala's lament. This year, in 25, he said, there is a curtailment of 57,400 crores made by the center in the state's receipts in the current fiscal. That is the fiscal ending shortly. Oh, sorry, fiscal which has just ended. And he further pointed out that while Kerala's eligible borrowing limit is 39,626 crores, to borrow, you need not only permission, but you need to be eligible according to certain norms laid down by the central government. He said we crossed the eligibility and therefore can borrow up to 39,626 crores. But you have been allowed to borrow, that is Kerala, only 28,830 crores. That's a clear 10,000 crores or less. So these are examples to underline the point, which brings me to the principle less than the factual examples of 293. There has been interesting analysis of Article 293, a little noticed article, till it was begun to be used by the central government in an anti-federal spirit, by prescribing onerous conditions to inhibit and limit the borrowing of states. The most clear example and the clearest articulation of this is by Kerala, and it's gone to the Supreme Court now, to say that 293 either has to be interpreted in this way or otherwise the various things done under 293 makes it violative of the basic structure. That's the argument of Kerala in a pending matter. But the basic point made is that the center has very cleverly, over cleverly, put insidious, quiet limits on how much a state can borrow. For example, it says what the state-owned enterprises, public sector units of a state borrow, will be counted in the total maximum of what the state can borrow, which means it will deduct a lot. Now, it's interesting that it could be constitutionally suspect to say that the state's borrowing is reduced by the amount its PSUs borrow. 293 does not seem to have any such direct power, but more than that, the 15th Finance Commission did dealt with the subject, but nowhere suggested that you should add the state PSUs borrowing to deduct it from the state's overall borrowing limits. It also ignores entry 43 of list 2, state list. Entry 43 says public debt of the state. This is entirely a state subject. And so long as you are able to manage your own enactments about fiscal responsibility and budget deficit, how does the center tell you to borrow less? By artificial cutoffs, like including the state PSUs borrowings in that total pool. In fact, Kerala is an extreme example because one of the few states where it has managed to reduce its deficit, the fiscal deficit, to 2.44% and the revenue deficit to 0.8%, and yet it is punished by these interpretations. So this is my fifth head of, my sixth head, my fifth head of fiscal federalism. The next is the most important in terms of current context, that is the role of governors. And let me start on the governors aspect by giving you three facets: our Constituent Assembly, the various commissions like Sarkaria, etc., which came later, which dealt exhaustively with the subject of center-state relations and the role of the governor, and by the established case law of the Supreme Court. And I'll just touch upon them. I'm going to do the job of a fan dancer, touching upon the subject without really covering it. But there is no doubt by reading the Constituent Assembly debates that the focus was clearly to make the governor the most nominal of all nominal functionaries. I would exhort many of you to pick up the debates and read across, from Durgabai Deshmukh to Shubhanlal Saxena to Saidullah to so many, of course, Dr. Ambedkar I'm not counting at the moment, and so many others. Most nominal. They say again and again that in fact, so I'll just summarize rather than talking, that A, there cannot be two swords in one scabbard. एक म्यान में दो तलवार नहीं हो सकती. No two CMs competing. No CM and a super CM. That's the sentiment. Second, that we will not have elected governors because that will lead to that diarchy. The word used is diarchy. Third, we will have nominated governors, and Dr. Ambedkar used the phrase, and this is a lecture in his memory, he used the phrase ornamental. This post is ornamental. He says it 5 times. And he says that we will nominate them, and I am fearful that since they have no powers, nobody may be ready to become a governor. He says that. Compare with the current contrast, and some people must be turning over in their grave. They talk again and again of having persons unconnected with politics, very eminent persons, objective persons, etc., which of course is a fond hope, and it has frankly been violated by all parties across the political spectrum. Krishnamachari specifically says he should not be the agent of the center. And I'll just read those two portions spoken by Dr. Ambedkar on 31st of May 1949. We felt that the powers of the governor were so, I'm quoting, We felt the powers of the governor were so limited, so nominal, his position so ornamental, that probably very few would come forward to stand for election. And this is why they said that he will be nominated and we'll have difficulty even finding nominees. If the governor is a purely constitutional governor with no more powers than we contemplate expressly to give him in the Act and has no power to interfere with the interior administration of a provincial ministry, I do not see any very fundamental objection to the principle of nomination. On 2nd of June 1949, a few days later, he repeats it. The first thing I will like this House to bear in mind is this. The governor under the Constitution has no functions which he can discharge by himself, no functions at all. There are so much more. I don't have time to quote to you from the debates. Many moons later came the extremely comprehensive Justice Sarkaria Committee report, which reiterated these sentiments. And in particular, for those of you interested in the nitty-gritty, paras 4.1.12, 4.2.06, 4.16.02 and 0.03 in a very large report say things like, a governor so selected may well seek to override the powers of the chief minister, leading to friction between him and distortion. And then they say, you must change the whole system of nomination itself. And then they say, that this is Sarkaria Commission, he must consult effectively with the chief minister, even for doing his nominal functions. Even for his nominal functions. And then they say in 4.16.20, the governor, while sending ad hoc or fortnightly reports to the president, should normally take his chief minister into confidence. So even that which he is doing, nominally sending reports, he must take into confidence. And of course, then are the powers, Article 163, 174, 175. Even there, his power to prorogue or call the assembly or assemble it or the address to the House are entirely on the basis of the Council of Ministers. The only exception is when the Council of Ministers becomes a minority or is at the cusp of a dissolution or is about to lose power. That is a well-known exception in English common law also. And then, of course, there are discussions on the assent to bills, Article 200, which the recent judgment deals with. But just to read to you Shamsher Singh and Nabam Rebia, enough for you to keep in mind. Remember, Shamsher Singh was 7 judges decades ago. Decades ago. And it said, Shamsher said, the function of the president, and it included president and governor both, the president and governor and the business of government belongs to ministers and not to the head of the state. It's his job, not my job. As I put it in another lecture, the chief minister has a fundamental right to do wrong. The correction lies with the electorate, not with the governor. There is no super chief minister. Nabam Rebia, which is more recent, says even his power to summon the House can never be used to impede a running government. We now turn to the recent judgment about which so much has been said, which I had the privilege of conducting in some detail. But people forget as to how it arose. I happen to be part of all the 3 processes of origination, and many of you will not know this from the press. The first set of petitions was moved on behalf of West Bengal, where there was a similar delay, both by the previous governor and now a more exalted constitutional authority, and by the current governor. The second was Punjab. Tamil Nadu was the third. So the honorable governor here was slow in copying the bad habits of other governors. The model was the same in all the 3 states. The periods of delay were different. So let us say about 15 bills. I'm giving an example only. In West Bengal there were 10, in Punjab there were 5, in Tamil Nadu there were more. Let's say 10 bills accumulate. Neither assent, this model is very important, the sequence. neither assented nor returned back. Kept pending. In Tamil Nadu, the highest period of delay was 15 months. 15 months. Some were 5 months, some were 8 months, but some were 15 months. When the matter came to me, I said, I'm surprised that the state government has been so patient. So we filed the petition. It is reported it's being filed a day before the petition in many of these states, not only Tamil Nadu. So the matter is coming next week or tomorrow. The governor passes 2 bills or 3 bills. Then the matter comes and time is taken on behalf of the governor. The other 7 out of 10 are pending. Then the next date, as you know, the court moves in a certain fashion, 3 weeks, 4 weeks, 10 weeks, 8 weeks. When it comes, arguments are fully contested that I will decide, but you cannot give me any direction to decide. And the first batch of these cases was heard in court number 1, headed by the Honorable then Chief Justice Chandrachud, sitting with Justice Padiwala on all the hearings. Finally, it led to a judgment in a case prior to the Tamil Nadu case, which is Punjab, on 10 November 2023, which I had occasion to argue. And the full issues which arose in Tamil Nadu didn't arise there, but it's a judgment copiously relied upon by Justice Padiwala in the Tamil Nadu case. The Punjab judgment, speaking through Chief Justice Chandrachud as he then was, held, pulled up the governor directly, for delay in assent. And did more, because there another situation arose. The governor there not only delayed but did not give his assent for the calling of the assembly. So they said he has no power. Once the government decides that you must call the assembly, he has to call. This power lies actually with the chief minister and the speaker. You are only an ornamental, formal thing. They decided that on 10/11/23. Now in Tamil Nadu, the same pattern was followed. But in Tamil Nadu, it is very clear that the sequence was that first there were the usual 1 or 2 assents, and then when the matter came up for hearing, they contested, and then they returned. Between date X and date Y, they returned. The Honorable Chief Minister talked to me, so I advised them to repass, and they sat on a Saturday in this state and passed it. It went back, the governor sat on it again. So people who criticize this judgment have to give an answer as to how there can be a constitutional right without any remedy. What is wrong in this judgment? Then, when it came back, after sitting for a sufficiently long time, knowing the constitutional law is that he is bound, he did something which he never did in the first round. He referred to the President. Justice Padiwala's bench, it is not a casual judgment or a hurried judgment. Twice came out with copious lists of queries and issues. We all complimented all the youngsters, young juniors who did night and day research. He gave those lists of queries and issues to me and the Attorney General opposing me. The matter was argued over 3 weeks with adjournments in between. Facets not raised were put in that list of issues. Thereafter, both the Attorney General and me made submissions on those issues, and Mr. Rakesh Dwivedi also, who was on our side. And then finally, the judgment came. And I want to say 3 things. First, extreme perverse actions require genuine remedies. You can't have operation successful, patient dies. This judgment is not a precedent to say that in every case I will go and it will be a deemed assent. That is a deliberate distortion of this judgment. Deemed assent is, what business does he have as a governor to sit for 1 year and 3 months? So if you take it to the extreme, then there is deemed assent. Nobody is suggesting there is deemed assent. Second, what is wrong in a 3-month period? Is 3 months too little to find out? There are only 2 things to find out. One, referral back, or it is so patently unconstitutional that can be either a referral back or conflicts with central law, send it to the President. This is done in 1 week. Even first and second year law graduates can advise the Honorable Governors across the country. So 3 months, what is wrong? Giving a remedy of deemed assent if you sit on it even after 3 months, what is wrong? Number 3, the argument is that this is not mentioned in the Constitution. I would say 50% of the beneficial law which this country today enjoys is based on what is not written in the text of the Constitution. Let me give you a small example. The ladies here should know this better than anybody else. Vishaka, sexual harassment at the workplace. Till today, there is no law. Justice Verma laid down the principles and said that these will apply in the interstices of the unoccupied areas of law. Where is the constitutional text which inhibits this? Putting a time limit where a governor is not doing this for so long, that's number 3. Number 4 point, the reference to the precedent cannot happen because the text of the article makes it clear that he returns it for reconsideration on the wisdom basis to the state, but on the conflict basis to the president the first time round. It is very clear that he is trying to delay and obstruct if he does it afterwards, because there are only 2 possibilities in the first round. There is no third possibility. And therefore, and I also want to most respectfully but very firmly ask, where were all the constitutional functionaries, howso eminent they are, and where were all the great commentators from across the political spectrum who did not utter a word when the governor was sitting on bills for 1 year, 3 months? They are giving pious lectures now. They are saying, "Arey, there is a big ulangan of the Samvidhan. संविधान को आपने उल्लंघित कर दिया है." But where is this when this was happening under your nose for 2? This is not happening in Tamil Nadu. This happened in West Bengal first, in Punjab second, and in Tamil Nadu third, to this degree. That process has been over 5 years. There is not a single statement condemning that. And when a judge painstakingly on a bench over several weeks with questions and answers with the Attorney General involved gives a judgment, you suddenly wake up. I have dealt with the Article 356 point, except to give you the point I made was that 356 is linked to artificial majorities, created majorities, lack of floor test, and or 356. It's not really 356. The best example of this is the Uttarakhand judgment, which I had occasion to conduct before a Chief Justice of the bench. And it is sad, and it can be said that he suffered a 2-year delay in coming to the Supreme Court because he heard 9 counsel, 1 on my side, myself, and 7 counsel on the other side over 1 month, and then gave a judgment according to his conscience saying that the last minute invocation of President's rule after failing to call for a floor test. So you know that if you have a floor test, he will win, he will win, he will win. You don't call a floor test. When it becomes impossible and you have to call a floor test the next day, you call a 356. He quashed it. The Supreme Court upheld it. That he suffered is another story altogether. But that promptitude of judicial review is the best antidote to anti-federal activity, which was not there pre-2000. The courts have become much more zealous and vigilant, and that has led to a major federating influence on the Indian Union. The 9th aspect, I'm going to finish in 5, 10, 7 minutes more. Very little noticed, and it will be tested sometime, but it is not tested on the ground that it is all for the public interest. That is the Disaster Management Act. Very few people have seen it because we actually thought that COVID is the end of the world. So anything and everything the government does has to be correct. Forget the power. Nobody is bothered about the power to do it. The context justifies the power. That was the approach in COVID. But the Disaster Management Act of 2005 is made with no regard to federalism. If you see its provision, and I'm not going to deal with it in detail, it gives the power on a declaration of a supposed disaster to as low a person as the DM or a person just above the DM to do anything and everything, irrespective of power in list 1, list 2 or list 3. He can give directions to the state administration entirely relating to list 2. And in particular, the sections which call for your attention is 10 and an overriding non-obstant clause section 62. Section 62 has a catch-all overriding, and it has been made without any regard to the federal principle. At some point, it is even the national lockdown, if you were to take it legally, the national lockdown would be illegal and unconstitutional. It's a different matter that the country cooperates and collaborates in a national crisis. It was not challenged. That's a different issue. Friends, I now come to the 10th aspect, which are the combination of more practical operational realities which are threats to federalism, not law, but the approach to opposition ruled states. Why do you find, for example, the role of the governor as a Sopari agent only in states where political colors are different from the central ruling party? You don't find this anywhere else. The issue of vendetta politics. These are also issues of federalism. When all the ED cases we have done, if you ask them, they give a very interesting statistic that less than 3 to 5% are political color cases, which may be true. If you ask them the second question, out of those 5%, what percentages involve coercive action against opposition leaders versus non-opposition? The answer is that in that 5%, 95% would be non-opposition, would be opposition leaders. This is another form of controlling federalism through coercive action, divisive, antagonistic. Dr. Ambedkar could never have thought of this. He thought of maturity, perspicacity, far-sightedness. These are all factors conspicuous by their absence. I now turn to another interesting facet of federalism, how to nullify that which the court has done for you. Court has already sorted out the problem, but you will go beyond your call of duty to nullify it, reverse it, in a total anti-federal manner. Again, I had the privilege of being part of both the 2018 and the 223 NCT cases. And I believe, if I recollect, Mr. Chidambaram was also part of the 2018. The 2018, and both are constitution benches, 5 judges. The 2018 largely settled the issue and said that, look, Article 239AA, which is a special part provision for a special, because Delhi is neither a UT nor a full state, so it's that hybrid amphibious creature. So they settled the law broadly, saying that the elected government must have all the powers minus three powers. But they did not specifically touch on civil service, because the question didn't really arise. The civil service question arose in 2023. And after detailed hearing, I was a lead counsel, we spent many days in a detailed judgment, definitively held that to have a government without control over its civil service is to have Hamlet without the Prince of Denmark, or Prince of Denmark without Hamlet. That judgment comes in 2023. Before the ink is dry on that judgment, and it doesn't matter, today you are in power, today the BJP will be worried if some other government comes in power at the center, the same law will apply against the BJP government of Delhi. But before the ink is dry, moves are made to bring it into parliament, a nullifying act, a reversing act. And how is it done? Complete sleight of hand. As I said, in a private transaction we call 420, 420. This is constitutional 420. Now, of course, 420 is gone. I forget the new provision. 318. Huh? 318. So we have been brought up on 420, so 318. Now, in this new judgment, they say that clearly services, as at present the law stands, is, because only 3 areas are with the Lieutenant Governor. Entry 1, 2 and 18. Land, law and order, public order, etc. Else everything is with the state government of Delhi, despite it being a 239AA. The new law by one act of one provision says, yes, all these three alone are with us, rest is with state government, but the power to transfer, appoint and move or deal disciplinary action with civil servants, by this new act, we change. Now you see the practical effect is, actually changes the entire 239AA. By controlling one item, you control all the lists. You control all the entries. This actually has happened from 23 till they lost the election in 25. I, of course, squarely blame the Supreme Court for not taking up the challenge to this new act, which many times was notified for hearing but not taken up. So the Supreme Court's unfortunate decision not to decide became a decision. A decision not to decide became a decision because the new act took force. The practical result, as all of you who have been MLAs or ministers or whatever know, that I cannot appoint him, I cannot transfer him, I cannot discipline him. So the officer actually tells, all the ministers have told me, yes, I have noted your concern, sir, I will see. I will see means he will go and consult the Lieutenant Governor or the Home Minister. If it is innocuous, he will do it, otherwise he won't do it. Now if he doesn't do it, you can't even transfer him from water to something else. You can't transfer him in Delhi. So this is federalism in action. The Honorable Prime Minister speaks of cooperative federalism. The Honorable Prime Minister speaks of competitive federalism. He speaks of very great notions of federalism. If this is the definition, then it is an Alice in Wonderland definition. Words mean what I say they will mean. They can't be real because this is completely anti-federal. Anyway, the jury is still out. The first thing which is now likely to happen is that petition challenging it will be withdrawn. So you'll have to wait for another day to decide it. Two more points. I'm sorry I'm exceeding my time, but it's important because they deal with federalism and they are very new. The first is one nation, one election. I had the privilege of being an expert witness deposing before the Parliamentary Joint Committee for over 2.5 hours, just last week. So I'm fresh with it. I certainly will not take 2.5 hours on that. I will just summarize the three broad heads. I started by saying that I at one time was a votary of one nation, one election. In fact, almost 2 decades ago, after the first proponent, Mr. Advani of ONOE, I wrote an article in the Hindustan Times supporting it. It appeals actually to all of us in the drawing room, on the streets, as a very orderly, uniform, cyclical thing. It appeals to our sense of order. One nation, one election, one button, everything is over in one time. So it's a naturally plausible concept. But if you look at it carefully, I said it is unconstitutional on 3 fronts. The first is at the state level. The whole ONOE is based on pressing a reset button. So the national election takes place now, that becomes the appointed date. Let's say 1st January 2025. Now, some elections in the natural course, there are only 4 states in India, by the way, only 4, where already the state cycle of elections is synchronized with the center, which means 28 odd, how many we have? Union territories are 7. So some 28, 30 states in union territories, their cycle of elections is different. So this is the appointed day. One election is happening in state after 3 months, one is 6 months, one is 2 years later. So therefore, the reset button means that you can't postpone the election of that state, because that is not permitted in the Constitution. You will prepone it either to midterm or to some specified date which they will give, which means differently, if a state has an election after 1 year of governance, it will lose 4 years. If it has an election after 4 years, it will lose 1 year. It is very clear that this first pressing of the reset button at the state level, I'm not talking of center, I'm not talking of parliament, the pressing of the button at the state level will reduce the mandate of the people who elected the state representatives drastically. The statistical average given by De Bruy's work on this is about 14 states will lose drastic reductions and 14 others will lose lesser reductions. But they'll all have to be reduced because they're not in sync. Now, this reduction and curtailment of the democratic mandate and the will of the people for this MLA, for this state representative, is further exacerbated when governments fall midstream, second time. So I elect a new government with the reset button, but you can't control democracy. Therefore, the government falls. So the button has to be pressed a second time. So you can have theoretically multiple presses, but the first press itself gives you a curtailment. Now, this, I have said, is clearly a assault on federalism, because the state cycle of elections, which is the state mandate of democracy, so I elect you for 5 years. It's a different matter if democracy falls that government less than 5 years. But here that government falls by compulsion of law, not by democracy. So my mandate about my MLA is curtailed by law, not by my consent or by the MLAs defecting and falling naturally. So that, I said, would be a hit on federalism, and federalism in innumerable judgments, starting from Keshwananda to Bommai onwards, has been held to be a basic part of the basic structure of Indian Constitution. The meaning of basic structure is that if you pass a constitutional amendment saying X, this is a constitutional amendment saying this is valid, that constitutional amendment saying this is valid is itself unconstitutional. That is the meaning of basic structure. So the state cycle is hit by federalism. The central cycle is hit not by federalism, because there is no state involved, but it is hit by another principle which is part of the basic structure. So federalism is one principle part of the basic. Both are hit by basic structure. Both the principal cycles are hit by basic structure. One is hit by basic structure through federalism. The other is hit on the same principle. Of course, it happens much lesser in parliament. Parliaments don't fall as much as state governments can fall. But if, and this will happen not on the first reset button, because the first reset button will be set by law. So 2029 is going to be proposed, was proposed by the Kovind committee as the, but during the course of a parliament, if it falls after 1 year, then the next parliament will be only for 4 years. But if it falls after 3 years, the next parliament will be only 2 years. The result is that the will of the people, which is separately, not on federalism, held to be part of the basic structure, because democracy and free and fair elections in the will of the people is part of basic structure in Indira Nehru Gandhi's judgment in 1975, will equally be culpable. I am not talking of multiple falls of the government, that will make it worse. The third ground where it is badly hit is, remember one very interesting thing, the Kovind committee, very strangely, was asked the how question, admittedly not the if question. They were asked in the terms of reference, how do you do ONOE? Not whether ONOE is constitutional or if you can do ONOE constitutionally. The terms of reference are not there. The Kovind committee say that. So if you ask only the how question, then there again is a sleight of hand. Now the third area where there is constitutional culpability is that the Kovind report recommends the state cycle change by changing the Constitution Article 83 without state ratification. Technically 368 requires state ratification only if A, B, C, D, E, F articles are involved. Now clearly A, B, C, D, E, F articles are not involved. But if federalism, which is part of basic structure, is involved, then state ratification is a must, because you have to ask those who are the most affected. You are curtailing a state cycle by 4 years and you are not even having it ratified, the constitutional amendment. It is anomalous. It is contrary to common sense. It may even be uncommon nonsense. Therefore, these are the three broad heads. There were many other issues, of course. There are good suggestions there about a uniform electoral roll and all that. There are good things. But otherwise, this is another very major assault on federalism. Well, friends, I think all I have subjected you to enough. Let me end by saying that federalism is what federalism does. Federalism is not just a rhetorical slogan. It is not just a big word embellished with further adjectives. Sorry, I forgot one last thing before that. CBI, we have forgotten. Another major attack on federalism. CBI is like a bull in a china shop in many states. It is an unwanted, uninvited guest to a non-dinner not being hosted by the state. There are any number of cases where after withdrawal of consent, I am doing a case from West Bengal, and by the way, on this issue, a civil suit is pending under Article 131 between State of West Bengal versus Union of India. The argument of CBI there is that yes, you have no consent in West Bengal. Yes, this offence arose after withdrawal of consent, but we have jurisdiction because part of the, very small part of the offence involved movement of goods on railway land. And railway land is central government land. If this is the way you interpret, then why was Section 6 enacted? Remember, when the Delhi Special Police Act was made, it was a specific recognition of federalism. Specific. One section allows you to go only where the central government allows you. The CBI cannot pick the city or the offence. Only central government can pick it for them. Only after they enter the room and start investigating this house, then only CBI will decide, then they are not interferable. But this has been shattered across the country in any number of cases, where on specious grounds, on very flimsy grounds, on almost puerile grounds, the central government asserts a power to enter. The railway example is the most extreme. There are, of course, two well-known exceptions where a CBI can come as an unwanted guest. Nobody is objecting to them. That is if the High Court sends it or the Supreme Court sends it. That is not the case I am talking about. Well, friends, as I said, as I end, federalism is what federalism does. Federalism is not merely a fancy word embellished with adjectives, as a lot of people in the political arena are doing. It depends on the spirit in which you operate it. It depends on the institutional mechanisms and the structures to which you add the genuine spirit to operate it. Above all, it depends on the men and women who understand that spirit first and then operate it. But in the end, we must treasure it. We must cherish it as a treasure. We must respect it, and when in doubt, we must enlarge it. We must expand it. Otherwise, succeeding generations will not forgive us. As Iqbal put it in a very well-known line, "Lamhon ne khata ki, sadiyon ne saza pai." What is destroyed in seconds or destroyable in seconds, generations later will blame you for it and suffer for it. Thank you very much. I'll do question.
What's your opinion about the conflict between judiciary and executive? Can this lead to a breakdown in the law?
See, your question can be the subject matter of a separate lecture, and everybody here will revolt if I start answering it in that spirit. Conflicts between legislature and executive are not new. But if there is the same spirit of understanding and wisdom which I talked about, they are easily solvable. It's happened all the time. I heard recently, all of you would have heard, a very eminent constitutional functionary saying, and I have deep respect, that the parliament is supreme. Now I wonder how many lawyers there are in this audience. Most are lawyers. I don't know how many of you were taught that parliament is supreme. As far as I am concerned, I was taught that the constitution is supreme. Now if the constitution is supreme, then neither parliament nor executive nor the judiciary is supreme. But judiciary has the exclusive power to interpret that which is supreme, namely the constitution. If I am the only priest who can interpret that temple's admission or rituals, then necessarily I will have the last word. So basic structure, ultimately the court decides, because that is the priest which protects the temple of justice. And the temple of justice is the Constitution of India. So there is exaggerated, distorted conflicts created. With some degree of restraint and wisdom, they are all solvable.
Hello, sir. Thank you very much for very beautifully and eloquently explaining to us how a country that was conceived as a unitary, with a unitary nature, slowly and in an unintended and accidental manner is moving towards federalism. So we can, the way you've explained it tells us that this is an evolution of our constitution and thought process itself. My question is specifically about the Jammu Kashmir case. You know, the abrogation of Article 370, when the Supreme Court took up the case, they dealt with a lot of things, but one thing that they totally ignored was the demotion of the statehood of Jammu and Kashmir to a union territory. What are some of the consequences of Supreme Court ignoring that particular act of the government? You know, do states like us, do we have to worry about you know, the impact?
So keeping my response short to your question and not your comment, you are absolutely right. 370 and statehood are two entirely different concepts. Let us not get into the first. That ship has sailed. Whether it will be dealt with in a different way in the future or not politically, I can't say. But I believe that that ship has sailed and it's futile to expend energy and time on that. The real issue is statehood. On that also, almost everything is clear. There is a statement recorded in the Supreme Court that statehood will come within so much time, or not so much time, shortly. There is a broad consensus. Everybody, even the Lieutenant Governor, never says that statehood will be delayed too much. There is a declaration time and again in different speeches by the Honorable Home Minister and others that yes, it is going to come. Only question is when. So I think that has to come as soon as possible. I do confess that issues like Pahalgam do create a psychological delaying factor. We have to understand that as a factum, not as law. But in principle, at the moment, there is nobody in the country which is objecting to or in principle saying no statehood. It's only a question of when. Now, there is some leeway. I have no doubt that if that is delayed irretrievably or irreversibly, there will be a fresh application of petition to the Supreme Court to lay down a timeline.